Good morning, everyone. It's Wednesday, I believe. February 1st, 2023. It's 11:38 a.m. So it's still morning. Good morning. Anthony Tharp here again, and as I've indicated in previous videos, my main focus is on the irregularities and corruption and fraud and even irresponsibilities that takes place at the court level, or the Supreme Court specifically, that is causing this country a whole lot of hurt in terms of its economic development, and it's costing a lot of investors money and losses, and creating a fear to put your money into Jamaica. Now, I invested a ton of money and resources in this country when we started businesses to do major developments on the island. Developments that typically weren't being done, because when we came in, one of the things we identified in the market right away, that there were individuals who were asset rich, and I'll explain that, but cash poor. I mean, a lot of Jamaicans have land, for example, but they don't have the means or the resources to develop those properties. So we embarked on a policy to do joint venture developments with property owners, especially property owners who didn't have the resources, whether in terms of cash or technical knowledge or know-how. And since I was invested in the real estate industry for decades, when I came back to Jamaica to get into real estate, I was already almost 4 decades, almost 40 years into real estate development. I started really early, but I did very well. I understood the market, still understand it, and I found that what Jamaica needed was an aggressive plan of action when it comes to developing real estate, which is really one of our primary assets. Apart from the human person itself, the market in Jamaica is predominantly real estate. We need real estate to do agriculture, you name it. But in effect, our primary objective was to see how we could work with property owners who didn't have the resources to build their economy, or they were sitting on property that they would eventually lose because they didn't have the means to maintain it. So one of the things we did again was joint venture agreements. And before we entered the market, we met with the real estate board. We spoke to officers at the real estate board. We also reviewed the real estate board's directives. We met with the FSC, and we went through exactly what we'd be doing. And so when we came, there were no issues when we started our business. And somewhere in 2007, we came under attack from the FSC. And of course, everybody jumped on the bandwagon because it was a popular thing to do, without typically looking into the facts and the objectivity of what was going on. So just like I've said to you in previous videos, I won't go around condemning outright anybody with the SSL matter and Mr. Bolt's matter until all the facts are known, because I am not aware of the agreements that were entered into and what they spelt in terms of expectations from either party. However, based on what we've seen and in the press, if accurate, there were some irregularities, major irregularities that took place. But that said, I've always dealt with facts and objectivity, and hence the reason I have taken on this task of really challenging Jamaicans to stand up and let's fix our judiciary. Because again, I firmly believe that unless we have an honest judiciary that has integrity, where we can trust the persons who work there to be honest and law-abiding, then this country is going to fail. And we can see the results of failure of a failed state in our neighbor, Haiti. And sadly enough, that country is deteriorating even faster because people refuse to stand up and do the right thing. So that said, we entered an agreement to develop several properties across the island. Montego Bay, Westmoreland, Manchester, which is pretty close close to Mandeville, Hanover, and in Clarendon. We also looked at developments that were existing in St. Thomas. However, we did enter a joint venture agreement in Clarendon with a Miss Valerie King. And when we entered that agreement, Miss Valerie King found us at our offices that were based in Mandeville. She said she got the information from one of our sales rep at the time. And when she came to the office, we explained to her that we weren't interested in buying land. Land was plentiful everywhere in the world. Our prime objective was to do joint venture agreements with property owners who didn't have the means to conduct the necessary measures that would, cause the development of property. So Mrs. King said she had 340 acres, and so she wanted to enter a joint venture. We explained to her, because she came to the office like 3 or 4 times, and she went over. We explained to her. She was saying she wants some money up front because she's in some juice business, and so we don't indulge in that kind of thing. And if you're going to do a joint venture, it's a straight up joint venture, no crisscrossing of our policies. So eventually she came and said she wanted to sign a joint venture agreement, which we entered. And in the day when she was supposed to sign, she said she wanted to take the agreement to her attorneys. Of course, typically you don't want your agreements to leave your office because you don't know what people might go out there and try to do with it, because people are unscrupulous. And so there were proprietary issues, so we drafted our agreements in a certain way that would offer maximum protection to both parties. So we were hesitant at first, and the staff was telling her no, she'll have to come here with her attorney and sit down and go over the document. So I say, you know what, since this is somewhat a new business and we wanted to get people comfortable with our approach, give her the document. Let her take the document and go review it with her attorney, and when she was comfortable, she'd come back. So some 2 weeks after giving her the agreement, and she signed it, a big old agreement which says at the top, joint venture agreement. Nothing in the agreement said sales or anything. So about 2 weeks after she came back, she said she met with an attorney. They went over the documents. The attorney acknowledged to her there was no issues that he saw that was threatening to her in terms of fraud or anything, or in fact it was to her advantage. So she came, she signed the agreement in company of a friend, and she signed the agreement. And then after signing the agreement, of course we wanted it certified or witnessed, so it was signed and witnessed by her own parties. We signed the agreement and we left it at that. About a month after we drafted plans which we had done prior to her signing. We presented them and said this is what we'll be pursuing in terms of the development. So it was 300 plus acres. She explained to us that the government had purchased or bought 30 acres from her because of squatting. And that was one of her fears, that in squatting on the property, she would eventually lose the property. So the government had already taken 30 acres, and so we had 311 acres to develop. So we laid out a plan of action for the entire 311 acres. And so we went to the Ministry of Lands to convert the property from straight agriculture, to residential, commercial, mixed use. And when our team went to the Ministry of Housing on, I think it was Hope Road, they went in there, or Ministry of Lands, sorry. Ministry of Lands said when they looked at the title, the title to the property was in the name of the Ministry of Housing. Now that shocked us because the documents that we were presented with show that Mrs. King was in fact the titled owner. So the team came back and we had an in-house attorney, Mr. Shim Kui, and they came back and said, well, apparently the title was in the name of the Ministry of Housing, and that presented a major problem, of course, because Ministry of Housing, we didn't know what was the ownership status. So we contacted Mrs. King and we said to Mrs. King, you gave us a title that showed you were the property owner, or a copy of a title, but yet Ministry of Lands is saying it belongs to Ministry of Housing, and we contacted them. They confirmed it, that it's in their name. So she explained that, when they purchased 30 acres from her because of the squatting, the Ministry of Housing said they would handle the transaction of the title work and cutting off the subdivision of the 30 acres. But in doing so, they would want her to transfer all the lands to them first, and then they would subsequently do the subdivision and then transfer back the other title to her. So we didn't understand why the ministry had to go through all of that, but that's what they required, according to her. So we contacted the ministry. The attorney went down with a number, I think about 2 other members of staff that were handling the development. We assigned them that project. And when I went down, the Ministry of Housing said, yes, indeed, that was the story. And they apologized for not completing the transaction, and therefore they would pursue it, and as soon as they were done, they would get back to us. So we waited on the ministry. This was in 2007, I think. Around 2007. And, it kept delaying. Every time we contact them, they say, it's being looked at. So we told them, listen, we weren't interested in putting the title in the company's name. Let it go back to Mrs. King's name. It will give her the comfort zone of knowing that nothing nefarious is going to happen. So they did that. But we didn't know. So in 2011, we got to a point where we said enough is enough. So we went down to the ministry. I flew down and I went down to the Ministry of Housing in New Kingston, that tall building. And we met with one of the managers there, and we said, listen, enough is enough. It's long enough, and you're holding up the development, and you promised you'd have gotten this done and gotten it back to us. So if we don't hear from you within a week or so as to what's happening, then we have no choice but to take legal action. So the lady was quite helpful, and she said, all right, we're going to check out what's going on. So they went, and apparently said they have to go check their archives because they couldn't find the paperwork. In the same week, the lady contacted us and said, guess what? We had completed the retransfer and sent it to Mrs. King from 2009. And so they were clear. So we contacted Mrs. King and said, what's going on? We've been waiting. We wrote to you several times. You said you didn't hear anything from the ministry. What's going on? I said, we already drafted plans. We paid attorneys to sort out the paperwork. We're ready to move forward. The agreement you signed is binding. Mrs. King just went mute, wouldn't respond. So we were forced to file a claim for breach of contract when we did. So all of that said, we signed a claim for breach of contract, and we ended up in court. And Mrs. King now, eventually, she said, okay, she had wanted to get out of the agreement. She did that. She had sent a letter, which I wasn't aware of until she told that story and we checked it. She had sent a letter some weeks or months, I think 3-4 months after signing the agreement. Now the agreement was signed as binding upon signing, which means that letter would have been moot in any case because it was inapplicable. So anyway, we said, well, that said, we wanted to pursue the project. We had a right. We spent money and time and energy, and we even got attorneys to work on the documents to get back to you. And we didn't think it was necessary to put it in the company's name because we wanted you to be comfortable. And she started one negative attitude, just ignoring everything. So we filed a suit against her. And it eventually came up for hearing, for trial in let me see now, in November of 2017. So we actually had trial for about 4 days. November 8th, 9th, 10th, and 12th of December. Okay, so it started in November, and then the 12th of December was the last date of the hearing, 2017. So at the end of the day, Mrs. King's defense was she didn't know she was signing a joint venture agreement, and she was confused, and that was her argument from her attorney Alexander Williams. And of course he was there performing without any kind of facts or evidence because the agreement says joint venture. So in cross-examining or putting Mrs. King on the stand, after saying to Mrs. King, you know what you're doing, it's hurting other joint venture partners, because it's not just us, there were other people who came on board with your authorization and consent as joint venture partners, and this would be hurting them if you simply got away with walking out of an agreement that was binding. And she was trying to pretend that she didn't know she was signing on a joint venture agreement. So at the top of the agreement, I said, Mrs. King, look at the agreement. It says joint venture at the top. There's nothing in the agreement that says sales agreement anywhere. And plus, there were penalties in the agreement for you to, if you were to pull out of the agreement. Eventually, Mrs. King said, yeah, she knew she was signing a joint venture agreement, and that was that. So at that point, we said to the court, well, there you go. She admitted signing the joint venture agreement. The terms of the agreement are binding. It's stipulated. Everything is clear. There's no confusion, nothing. Mrs. King knew what she was getting. She was getting paid for the development rights as well as a 5% percentage of our profits, which would be significantly more than what she was being paid for the development rights. And we paid her the development rights that she was to be paid for out of the transaction was 2 million US dollars, which was way more than the land was worth. But we wanted to pay premium because we wanted to show people that we could be successful. The landowner would come out on top because she's not only getting the value of the land for the development rights, but she would also be getting a percentage of the profit, which would be significantly more. But for whatever reason, and it makes no sense to me, it's illogical, common sense, you're making more money. Mrs. King had the attitude where she didn't want to deal with business with me according to her terms, her term, or argument on the stand. She was tired of me, she wanted to get rid of me, and she didn't want to do any business with me. So we ended our argument and our cross-examination and said to the judge, there you go. She said she signed the agreement. She knew I was signing a joint venture agreement. So we figured that was that. The judge adjourned the matter and went off to make her decision. When she came back on the 12th of December, the judge said she believed Mrs. King. So I said, believe Mrs. King what? Mrs. King admitted to signing the agreement. She believed Mrs. King. This was a Justice J. Tai. Mrs. Justice J. Tai or Miss Justice J. Tai. So we're like, she admitted signing the agreement. It's binding. What's the issue? The judge went into some long roundabout nonsense about, well, the agreement, the joint venture agreement, couldn't be enforced because the agreement was illegal because we signed it without having a dealer's license, a real estate dealer's license. So I said to the judge, according to the law and the Real Estate Act, we are developers and we didn't require a dealer's license to develop property or sign a contract. She said she begged to differ. Furthermore, I said, in any event, Mrs. King is a joint venture partner. She's part of the development team. So the fact is, we're developing land that's part of the development team. So how would not that contract not be valid? She said we needed a real estate dealer's license, and I'll quote, real estate dealer's license, before we could enter any kind of contract to develop property or joint venture agreement. Of course, we knew that was grossly incorrect, and so we asked the court for leave to appeal. She said she wasn't going to do it, and I was lucky that I wasn't going to go to jail, in so many words, because of the illegal agreement we were signing. And she was shocked that we had entered this kind of agreement knowing that we were not legitimate, and implied that every agreement that came out of this joint venture, which was illegal, was itself illegal, and therefore we had no standing. Mrs. King didn't have to honor the agreement, and that was that. She didn't give leave to appeal, so we filed an appeal, which ended up in the appeals court. So the court gave us leave to appeal because we explained to the court, the appeals court, that not only was the judge confused, she wasn't aware of the law, and she misinterpreted the law, and that in fact, if this ruling was not overturned, then her ruling would have essentially changed the law of the land, the Real Estate Act. And what she ruled was essentially saying now that every developer who entered an agreement, a joint venture agreement to develop property, or develop property without a dealer's license, was doing or did that illegally. Which means every other agreement that those developers went into with anybody, any kind of agreement, sales agreement or other, would be illegal. And so we said to the appeals court, if this isn't overthrown, then the entire real estate market and the mortgage industry would be ruined and cause the collapse of the banking sector. So we were waiting from 2017 to, I think we went to trial in 2020. Hearing, sorry, at the appeals court, 220 or 221. But it's now in front of the appeals court. But because time is of essence, and we've been asking the court to expedite, and we know that we asked the court for a lot of decisions on this matter. But we pointed out that it was essential that the court expedite the matter, because if they didn't, the time-sensitive nature of the agreement, the property was there, and we had gone several times and seen squatters or potential persons squatting on the property. We had gotten information that Mrs. King was attempting to sell the property while this was going on. And when we raised that in court, she said she wasn't, but we went and found that there was some agreement with another developer to enter and develop the property. So we notified the court, and we're still waiting on an answer. So today I'm here to say to every Jamaican that acquired or purchased property from any developer or any bank or any mortgage institution, I won't say mortgage institution, but lender, that purchased property that these developers did without having a dealer's license, a real estate dealer's license, those contracts are illegal and are unenforceable according to the ruling of Justice Tai. Now, you might not understand what I'm saying, but let me explain clearly. The contracts you sign, if you purchase it from a developer or from a bank or anybody, or a bank financed it, all those agreements are illegal according to the ruling of Justice Tai. Which means, technically, you won't have to pay these banks any money on the loans they gave you, because the contracts they had you sign, and you giving them a mortgage. And I'll point out that the banks didn't give you a mortgage. You gave the bank a mortgage. That's how it works. A mortgage is a security instrument. It's not a money instrument. It's a security instrument which gives the right to a lender or a lien holder on your property to have the right to sell your property or possess your property and sell it if you fail to pay back the loan. So in short, because of the ruling of Justice Ty, none of that foreclosure thing could work against any property that you have that came via a developer that didn't have a real estate dealer's license. So I'm saying to you, check the persons that you purchased the property from. Any developer, and I mean any, whether it's NHT, whether it's those major developers, Gore, you name it, check it. If they didn't have a real estate dealer's license, then you can pretty much stop paying your mortgage. Why? Because the mortgage agreement that you gave in exchange for a loan came out of an agreement to purchase a property that was illegally built, illegally sold, and the contract that you entered was illegal. Now I know Gore does a lot of joint venture developments as well, and I'm leaning on that based on the fact that the judge ruled that because we entered a joint venture agreement that was essentially, according to her, illegal, then it means any company that entered a joint venture agreement with anybody else and became developers of those properties, those agreements would be illegal and not binding. So the persons that entered the agreement with the joint venture partner could walk away from all that agreement, not give them any share of the profits, and pretty much keep their property for themselves, because it is illegal. That money is illegal, and it's a crime for them to essentially pay you any money or you pay them any money, and any sale of land or property from your development would be also illegal. So the people who bought the land and the property through this development scheme would also not have to pay any mortgage or money to you for the property. And the loans by the bank, though granted to you, were unenforceable because they came out of an illegal agreement. Talk to an attorney. Talk to your attorney, see if they can explain what I'm saying to you. So this is a gift to you, because we're tired of waiting around, because we said we would wait until the matter is settled in order to ensure that the market doesn't collapse and the banking industry is protected. But nobody cares about us. We spent our money, we developed, we entered agreements that were honestly entered in. We did nothing wrong. Here comes Justice Ty on December 12th, after hearing Mrs. King admitting that she knew she signed a joint venture agreement, saying that agreement was illegal because we did not have a we didn't have a real estate dealer's license before we entered an agreement with Mrs. King to do development of her property. Now, I went to the real estate board and I spoke to officers there, and the officers said, but the judge is wrong. So I requested a letter, which they had promised to produce a letter stating that her judgment or her decision or conclusion was wrong, and that the developer did not need a dealer's license to develop property. Now, I don't know how the judge went from developing property to entering an agreement, because there could be no law, there are no laws that could prevent anybody from entering an agreement. But she's saying before we could enter an agreement to develop the property, then we needed a dealer's license. And since we didn't have one, we weren't required to have one. My company was already registered as a developer with the real estate board, because we had approved developments and which were ready to go to market. So in short, this is a gift to everybody that's been paying a mortgage, that came out of a sales transaction, that came out of a developer that did not have a dealer's license, a real estate dealer's license. So first of all, check with the developer that developed the properties you bought. Then make sure that they don't have, at the time they sold the property to you, they didn't have a dealer's license, a real estate dealer's license. Even if they had a developer's license, it means the sale was illegal, the development was illegal. Any contracts or agreements that came out of that would be illegal, including the mortgage you gave to the bank, which is a security instrument, and including the money that the bank paid over to you. They would have to find a way now to go collect back that money from the developer, because the developer caused the illegality because they didn't have a dealer's license, and therefore you would not be liable for money that the bank lent you based on agreement they entered to pay off this illegal developer or development. And so in short, you're neutralized from that position. Now I can say this to you because professionally I am a mortgage broker. All right, I just don't practice. I'm a mortgage broker, and I was a very good person as it comes to the profession of mortgage brokerage. All right, so here's a gift to you again, and I'm going to wind up this section of what I have to say is that go check those facts. If you need to make comments, send them to me. I'll respond, but contact your bank, the developer, and once you find the developer did not have a real estate dealer's license, start putting your money in an account that is your escrow account. So when and if the court do come back with a ruling that's contrary to what Justice Ty did, you will have the money to pay the bank. But for now, take those resources or money that you're paying to your bank as your mortgage, open an escrow account at another bank so they can access your money, and put it in that account and keep putting it there, and explain to the bank that based on a ruling from Mrs. Justice Ty on December 12, 2017, the mortgage that they gave to you and the agreement that you entered to buy that property from was an illegal contract because the developer didn't have a real estate dealer's license, and therefore the money they lent to you was, the collection was unenforceable because everything based coming out of that developer's illegality is unenforceable, illegal, and the developer should be in jail according to Justice Ty. Now I'm saying this because this is what I was told, and the ruling is there, and I gave you the case that she ruled on was in the Supreme Court, claim number 2013 HCV 00464. All right, so the Supreme Court civil claim number 2013 HCV 00464, and we filed an appeal, and that appeal number is number 43 of 2018. So tell your mortgage brokers or your banks that they need to go pull the ruling on this particular matter, which is again in the Supreme Court 2013 HCV 00464, and so they know that whatever you're saying is legit and legal, and that you don't need to pay any note. You're not paying a mortgage, remember, you're paying a note. The mortgage you gave them is a security instrument. The note they gave you is a financial instrument, a money instrument, a debt instrument. So you're making payments on your note. You're not making payments on your mortgage. All right? So just some education there. Okay, have a good one. And this is just to show you how the incompetence in court can ruin a nation. Because if the appeals court upholds this ruling, every person that ever gave these banks a mortgage or purchased a building from these developers would have no legal obligation to honor those agreements, because according to Justice Ty's ruling, which changed the law, all those agreements are illegal. Now, the ruling changed the law from what it was. So technically, because of a ruling that came out of the Supreme Court, Justice Ty, T-I-E, changed the law from what we understood it to be and what we're told it to be, that a developer did not need a real estate dealer's license. That changed when she made this ruling. So again, you can take advantage of this, put the money in an account, and wait to see what the appeals court does. But for now, you don't want to keep giving money, because if the appeals court rules in their favor and enforces or affirms the ruling of Justice Tai, it means that you won't have to pay any mortgage. All right, the bank would have to write off that loss. And yeah, it's going to hurt the banking industry, but guess what? That's what happens when you have incompetence in the courts. And that's why I keep saying we cannot avoid or not deal with the corruption and incompetence and fraud that's going on in the court. Because if Justice Tai had simply gone to the law of the land, she would not have made this ruling. And as a matter of fact, in her ruling, which you can pull, see, Justice Tai never even went to the section of the act that deals with developers, and I pointed that out to her. So how are you going to make a decision about developers? And this is a judge now, you know. You're going to make a ruling about development and developers and their right to develop property and enter agreements. And I repeat, nobody needs a development license or a dealer's license to enter any agreement for sale of real estate or joint venture or any kind of agreement. But anyway, she said that we needed it. So again, she changed the law of the land, and which means now that law is neutralized. Because I went to the real estate board, as I told you, and after the officer said they would give me a letter, when I went back to the letter, they said, oh, you know, when they presented it to the CEO, which was a lady, I don't even remember her name, the lady came back to me and said she couldn't do the letter, or she couldn't sign the letter because she can't comment on anything that's in the court. Of course, I told her she needs to get a job that she understands. Because I don't know, you're a CEO of the real estate board, and this is a dramatic ruling, a significant ruling. And then when we come for you to clarity, you're going to tell me you can't make a comment on it because it's in the Supreme Court and the judge is ruling on it. All right, so the judge ruled. It changed the law. It changed the rules of the court. So anybody that's developing property now, be aware that if you don't have a dealer's license, then you're doing it illegally. And anybody attempting to buy from them or bought from them or give them money towards that purchase, guess what? They're selling you that property illegally according to Justice Tai. I don't want you to go to jail, the developers. So all the developers, please pay attention. If you who are listening this video or watching this video know of anybody developing property or out to buy property, have them look into the issues that are just, in fact, it's not an issue. The court ruled on it, so it's finalized. Have them look at whether they have a dealer's license before you purchase anything from them, or before you get a mortgage, or not get a mortgage, here I go making the common mistake, before you give a mortgage, or before you get a loan. Then be clear on that. You check it out and make sure everybody that you know that's involved with real estate development, tell them they need to go get a dealer's license. All right? Not saying anything that's illegal, because I was the brunt of that. I suffered the brunt of that ruling. And so a 300-acre development that we had planned to do is technically null and void because of that ruling. We asked the court, to the appeals court, to deal with it. So we've been waiting since 2018. It was heard in 2020, I think, 2020. And we're waiting on a ruling from the court on it. But until that ruling comes, don't do anything illegal. And I'm saying that to all the developers. Until that ruling comes out, don't get involved with any illegalities. But if you want to challenge this idea, which I suggest you pick up the phone and you start calling the banks, calling the persons who you're selling property to, or the persons who are buying property. Call around, call the banks, call the courts, call the attorneys, and say what the hell is going on. Call the real estate board, because they need to come out and deal with this. They're the ones that should be appealing this matter, not me. But they haven't done it. So because they haven't done it and we gave them the opportunity to stand up and do it, then it means that you're in the clear if you stop paying your mortgage. All right? Thank you. Have a good one. And that's my gift for 2023 to you. Again, put your money in an escrow account at a separate institution. In fact, do it at for example, a credit union. And so you could accrue some benefits on that money. So if it takes another 6 months or less for the court to come through, if they come through in favor of the ruling of Justice Tide, then that's your money. You don't have to pay anybody. If they don't, then you have that money in that account that you could probably leverage additional cash to do other things. But right now you could use it to build up that account to put some money in your pocket and pay that mortgage when the dates come. And they can't charge you any late charge or late fees, because the reality is that they should have stopped collecting your money the minute Justice Tide made her ruling on December 12, 2017. So technically these banks are collecting money from you illegally. Alright? And they can penalize you for illegal activity. So until it's fixed in the court or fixed by Parliament, then they can't bill you for any late charge or any late fees. In fact, they owe you money during this illegal period from December 12, 2017, when that ruling came down. From then till now, the banks have been collecting your money illegally. Right? And that illegality won't be reversed or removed until the appeals court either overturns this ruling, in which case the legality begins at the point the appeals court overturns this ruling. So that's when you pick up back your payment. So between 2017, December 12, and 2017, all that money and mortgage you were paying should be in your bank account, and the banks need to pay your interest on it because they were engaging illegally.